From the opinion pages of the Wall Street Journal, this is Potomac Watch.
The law and politics of gun rights is our topic today as the Supreme Court overturns a New York gun law, while the U.S. Senate moves ahead with a bipartisan bill that attempts to make it harder for mentally ill or dangerous young men to get guns if they pose a risk to others. Welcome. I'm Paul Gigot here on Potomac Watch, and I'm here with my colleagues Kim Strassel and Kyle Peterson. Let's get right into it. A major Supreme Court decision today. The case is New York State Rifle Association versus Brune, and it involves the challenge by the New York Rifle Association, a couple of individuals, to a New York gun law that restricts the ability to carry weapons outside of the home. The decision written by Chief Justice Clarence Thomas, 6-3 in the case, 3 dissenters, the 3 liberal dissenters, but every other justice signed on with it. And Kyle, you've written about this case. Tell us about the opinion and why it is significant.
Well, let me start with the basics of the New York law. You cannot open carry a handgun in New York. And aside from certain exceptions, like for judges, in order to get a concealed carry permit, you have to demonstrate proper cause. And what that means is some particularized threat to your safety. And it has to be more specific to you than just living in an area that is plagued by crime or related to your job. And so essentially, that means you can't get one.
It leaves the decision to the discretion of the bureaucratic authorities.
Correct. And what the Supreme Court has done here is said that, yes, the Second Amendment extends beyond your front door. There's a nice line in the opinion. It's a 6-3 opinion. The writer is Justice Clarence Thomas, and he says the Second Amendment says you can keep and bear arms, and the definition of bear naturally encompasses public carry. Most gun owners do not wear a holstered pistol at their hip in their bedroom or while sitting at their dinner table. And he says to confine the right to bear arms to the home would nullify half of what the Second Amendment protects. So that's the first thing it does. And there are 6 states, including New York, that have these laws called may issue, where it's up to the discretion. And so it may require those 6 states to change their concealed carry regimes. The second and broader thing that this opinion does is it reiterates what the Supreme Court said in Heller, which was the landmark gun rights decision. And it has been a long time since Heller. The Supreme Court has not heard a gun case. And lower appeals courts have been essentially using these means-ends tests, judges deciding, well, what is the benefit of this law versus the burden on the Second Amendment right? And Justice Thomas here says, basically, you can't do that. Judges need to look at history and look at the text and make a decision about whether the conduct, the carrying, whatever, what have you, is protected by the Second Amendment. If it is, then that's it.
Kim, I'm not sure that Justice Thomas has been at your dinner table because you may holster a weapon at your dinner table.
That's a state secret, Paul. The Strassel family is known to get a little squirrely at dinner, so yeah.
But I want to underscore here the point that Kyle made about the distance in time that this has been since Heller and its follow-up that applied Heller to the states called McDonald. It's been more than a decade, and some of the justices had demonstrated some real impatience over the years with the unwillingness of the court to hear a follow-up case that would fill in the details and elaborate on what Heller meant in practice to gun regulation. Because since Heller, which found that the right to bear arms was an individual right, not merely one that some on the left had said adhered to a militia, but there was a lot of room in Heller for how local political jurisdictions could interpret it and what kind of regulations they could impose. And a lot of courts have said you can not only have these may issue rules, but you can also regulate any number of things. And really, the case law cried out for some elaboration. So this is very important as an elaboration, and it essentially is going to restrict these may issue rules very severely, if not entirely, where you're going to have bureaucratic discretion so that if Kim Strassel decides in New York City to apply for a gun permit, you couldn't get one, essentially. Very few people could could get them. And that's going to change dramatically now.
Yeah, this guidance was very overdue. It's also quite strong, as Kyle was noting, and as Thomas says in his opinion, too many courts had taken to doing a two-step process. One, looking at whether or not a regulation was in any way informed by history, but then the second step of applying interest balancing or means-end scrutiny. Does the ends justify the means of this law? And he said quite straight up, that is one step too many, telling everyone that you don't get to do that anymore. And that's going to make a big difference, not just in these shall carry situations, but in other situations where, for instance, people may be having discussions about banning entire categories of firearms, for instance. But this was also just a Thomas decision, up and up. He has been one of the loudest complainers about the fact that the court has been silent on this, and that too frequently courts have treated the Second Amendment like a second-class right. He has a great line in here. He says, if the last decade of Second Amendment litigation has taught this court anything, its federal courts too often are deferring to their legislatures on these questions of means testing and interest balancing. And he wanted to make very clear that the Second Amendment deserves a lot more respect than that. He once again says in the opinion, the Second Amendment is not a second-class right. He also makes a number of comparisons about how outrageous most people would find it to be if we had different means testing and interest balancing for other rights in the Bill of Rights. If you had to get permission from someone, for instance, and show that you had proper cause to speak freely. And so it was an overall reminder to everyone that they need to be much more cautious in this realm, but also with some very good guidance about how courts should go about doing that.
I think this is also, this case and this ruling, I think a demonstration of the importance of having 6 conservative justices on the bench and the ascension of Amy Coney Barrett to replace Justice Ginsburg. And I say that because I know from my own reporting over the years that one reason the court did not take a gun control case after McDonald was because there was some concern about where the Chief Justice Roberts would come out. And I've talked to a lawyer who involved in this case who said, well, we knew we'd get a concurrence of some difference from Chief Justice Roberts if we did get his vote. And sure enough, it was written by Brett Kavanaugh, concurrence, and joined by the Chief. And it makes a key distinction, and as it pains Kyle, to make a key distinction between the may issue regulation and shall issue regulation. So explain how that is important.
Well, I think it's important because the reaction to this ruling in some quarters is going to be that the Supreme Court has just made the entirety of the United States into the Wild West, and tomorrow everybody can show up in Times Square with their AR-15s and nobody can do nothing about it. And I just don't think that is true at all. And so the concurrence by Justice Kavanaugh essentially says that there are all sorts of regulations that states put on these licenses, that license regimes for carrying outside of the home is still constitutional, and they can include fingerprinting, background checking, mental health checking, training in firearms handling, laws regarding the use of force. Nothing in this opinion is calling those into question. The opinion just says that states have to give law-abiding citizens some objective pathway to a concealed carry license. They can't block that off entirely, but there are all sorts of regulations that they can put on giving out that license.
For example, a training course.
Right.
And what others?
Yeah. I mean, fingerprinting, mental health checking, fees and stuff like that. So I think there's going to be subsequent cases to ask, how high can that burden be? And there may be some blue jurisdictions that try to game the system and say, we will give you a concealed carry permit if you send in your application on the 29th of February in a leap year. And there may be cases like that. I'm exaggerating for effect, obviously, but stuff like that. And even Clarence Thomas says in a footnote of his opinion, he singles out lengthy wait times for processing license applications, exorbitant fees. If the burdens are such that they deny ordinary citizens their right to carry in public, then those may be unconstitutional. But we will save those for another day, and with any luck, these jurisdictions will get the message and not try to game the system that way.
Well, just take the training provision, for example. If you have a training requirement, you could see where some jurisdictions would say, well, you have to take a 6-month course. And, by the way, it's going to be so elaborate, it's going to cost you $5,000. I mean, that's going to be exorbitant for most people. So, that's one thing to watch very carefully. And many states will not do that because the implication of what Justice Thomas wrote is that we're going to be watching this very closely. But let's listen to a clip from Kathy Hochul, governor of New York, in reaction to this decision.
We just received some very disturbing news from Washington that the Supreme Court of the United States of America has stripped away the state of New York's right and responsibility to protect its citizens with a decision which we are still digesting, which is frightful in its scope of how they are setting back this nation and our ability to protect our citizens back to the days of our founding fathers. And the language we're reading is shocking.
Well, Kim, you can tell there's a calm and reasonable reaction to this ruling, but I think her reaction does suggest what the politics is going to be in certain quarters and how there will be attempts, as Kyle suggested, to add barriers to concealed carry gun ownership.
Well, she sounded very much like the dissent in this opinion, which I have to say I wasn't very impressed with. It was written by Justice Breyer, and it's mostly a long litany of hand-wringing and statistics about mass shootings and statistics on suicides and statistics on the number of guns that are in private hands and the culture of violence, etc., and the inability of state government to protect its citizens. I was amused. Justice Alito ran his own concurrence, and it mostly seemed like it was done as an opportunity to complain about the dissent and point out some of the holes in this thinking, noting that he actually asked the question, do the dissenters actually think, the minority think, that somebody who is mentally ill and walking out to engage in a mass shooting is going to stop because he knows that it's illegal for him to carry a handgun outside? And he kind of goes through some of the logic of this. But you're going to hear a lot of this over the coming days. There's going to be a real push, especially at the state level, to come up with some of these regimes that Kyle was mentioning to try to get around this. So we're not going to be done yet, I think, with the Supreme Court. But I do think that nonetheless, while it's not always addressed, opinions like this are nonetheless going to have a huge bearing on the entire discussion of gun politics. Because if you think about it, a lot of the proposals, for instance, that even just 2 weeks ago, House Democrats were going to issue or passed, even though they didn't have any likelihood of becoming law, there are a number of provisions in there that likely wouldn't pass constitutional muster, including, for instance, the quote-unquote assault guns ban. And with each one of these opinions that we're getting from the court that is further clarifying their view of the rights given under the Second Amendment, it is narrowing to a certain degree what would likely be allowed under not just a federal regime, but some of these state laws too.
All right, we're going to take a break, and when we come back, we're going to talk more about the politics of guns and gun regulation and the Senate bipartisan deal on gun safety when we come back.
From the opinion pages of the Wall Street Journal, this is Potomac Watch.
Welcome back. I'm Paul Gigot here with Kyle Peterson and Kim Strassel. And let's turn in the wake of the Supreme Court decision to the work that has been done in Congress in a rare bipartisan agreement in the Senate on a gun safety bill, I guess you could call it. Modest bill, indeed, but had the requisite 60 votes, and 64, in fact, to move to debate earlier this year after the senators on both sides of the aisle put it into draft legislative language. So it is going to be moving towards the floor, and we'll get a vote quite quickly. And let's hear from the Senate Majority Leader Mitch McConnell on why he supports the bipartisan bill.
There have been attempts at bipartisan talks after horrible incidences in the past, but they fell apart when Democrats would not sign on to anything that did not roll back the Bill of Rights for law-abiding Americans. Well, this time is different. This time, the Democrats came our way and agreed to advance some common-sense solutions without rolling back rights for law-abiding citizens. The result is a product I'm proud to support.
Kim, this is interesting case because you have Mitch McConnell there. You heard him. He's claiming a kind of victory, basically saying this doesn't impinge on gun rights. Democrats, meanwhile, Chris Coons, the chief Democratic negotiator, and even Chuck Schumer and others saying, no, this is a victory for us because we've managed to get Republicans to come our way on things like red flag laws and some other limitations on the ability of certain people who are dangerous to get guns and expansion of background checks. I guess the question our audience might want to know is, well, who's right?
You know what I really love about this compromise, Paul, is it actually really was a compromise. And I do agree with McConnell on one thing, even though he didn't give it the credit I think the only reason this is happening is because Democrats who have been absolutist on these questions, saying we will not do anything unless it's the whole hog, finally decided that it was to everyone's benefit to actually have some discussions and find some common ground. And let me give you like a good example of that. Republicans, for instance, don't really like some of these experiments that are going on with red flag laws in the states, in particular because they are concerned, and I'd say rightfully so, that some of the states that have sent them up have had very little concern for any due process of those who are being targeted by these courts and having their firearms seized. We can debate how well those are working, but that has been a real concern for Republicans. Democrats would like to see more of these red flag laws, and they'd like to see more money for them. The compromise in the end was that, yes, there will be money for red flag laws, but no state can obtain that money unless they have a red flag law that has a long list of due process protections set up in it, including the right to notify the person who is being targeted, their right to attend a hearing, to have counsel present with them, to see the opposing evidence against them, and to present evidence themselves. So this is how everyone came to the middle ground. In some ways, I'm actually hopeful that states who right now don't have some of those protections, if they really want some of that money, it's going to actually inspire them to do a better job and have a better focus on due process. That's what Republicans are certainly hoping. That's how you get to where we are. I think it's a win for both sides. I'd add one more thing. I think it's a little bit more of a win, and this says something about McConnell and how strategic he is. Probably a little bit more of a win for Republicans because they've now effectively put this issue behind them as well, too. And I think it'll be a while, given this, before there's the appetite for another big push for gun legislation.
Well, you say put it behind them if it passes the Senate, which I guess you expect it to do.
I do think it will. There is a bit of a push, although I note it's a little lackluster, not the usual thing you get from some gun lobby like the NRA. They don't like it. They know that a lot of the provisions in here are pretty common sense. So you'll have Republicans who vote against it, but so far it looks as though the 14 GOP members who voted to proceed will probably stay with it. The House is sticking around to do a very quick vote by the end of this week, and it could be to the president by this weekend.
Donald Trump came out against it. There is some opposition in the Senate. Josh Hawley, the Republican from Missouri, who has designs on the White House, is vitriolically opposed. Trump said in his statement, this is just the first step to the confiscation of your gun rights, which is, of course, not true. A long way from that. And just one factual point, Kim, when it comes to the red flag laws and the money for it, this is not a mandate on the states. This is a monetary incentive that says if you pass a law, such as a red flag law, or in some other cases, if you don't want to pass a red flag law, some states can use other measures, take the money, you will get some money. But it's not a mandate.
Yeah, correct. A couple of important distinctions. One is this is not a federal red flag law, which, by the way, is what Democrats wanted. They wanted to be able to impose red flag laws via federal courts. It's only grant money, as you said, for states that want to set up or already have a red flag regime, although, again, with certain protections if they want to obtain the money. And then you make a really important point, is Republicans have wanted to make sure that states that have rejected red flag laws, but nonetheless are moving in some way to have a crisis intervention forum. For instance, an alternative might be a mental health court, right? Something that adjudicates that you are a danger to yourself or others. And with that adjudication might come the finding that you should therefore not be in possession, at least for the moment, of firearms. States like Texas have been going that way. They wanted to make sure those states had access to the money as well.
The reason that I look favorably on this bill is that it maintains gun rights, but it makes an attempt, Kyle, to essentially keep guns out of the hands of the dangerous young men who have become, as I think so many examples have shown us, the perpetrators of these mass shootings. And either because, one of the provisions of this bill says we're going to put into the background check system juvenile records so that if somebody has been proven to be a danger through a conviction in the past, that's going to be flagged, and that could block them from getting a weapon. And then these red flag laws, too. I mean, we know that some of these killers, these mass shooters, they might not be mass shooters in 3-4 years because it's this particular point in their lives when often mental illness hits and they're particularly distressed. And if you can deny them a gun at that period without denying everybody else gun rights, it seems to me a reasonable public policy accommodation.
Yeah, I think so too. I would point to a study in 2019 of California's red flag law. And we wrote an editorial about it at the time. And here is one of the lines. It says, police were tipped off by school officials that a 14-year-old boy had praised mass shootings. He used campus computers to search firearms and terms like white power. Taken to a psychiatrist, the student said he was joking. So that was a red flag in California. And what I find remarkable about that is how similar that story is to what we have learned about the Buffalo, New York shooter. And I think there are difficulties with these red flag laws that people don't know they exist. People don't know what to look for. It can be a kind of a bureaucratic process to get them through. But I think there's lots of room for states to experiment with those laws. I don't think that money is the reason that they haven't so far, but if a little federal money dangled, get some legislators over the line, that might be worth doing. The other point I would just make is if this bill passes, I think it is also a blow to the idea that Democrats need to overrule the filibuster because the Senate just can't get anything done. It's structurally broken. I mean, what we find out is when the senators decide they actually want to pass a bill rather than just posturing, it's amazing what they can get done. And this is nobody's ideal, and this is a compromise. So it's not the law that any individual senator wants to pass. But I would also point out that states have their own powers. And why do we look first to Congress when something terrible happens in a place like Buffalo? The New York legislature, the Texas legislature, there's lots of room for states to experiment with new kinds of red flag laws or other kinds of restrictions, as long as they don't contravene the Second Amendment, like we talked about in the first half of the show.
One final note on the politics, Kim. You mentioned the political calculation by Mitch McConnell saying if this passes, put the issue behind them. They can obviously then move on and talk about, for the general election campaign, talk about inflation and Biden's various failures. Much better for them to campaign on that. What's the logic of the Democrats here? Because I suspected all along that maybe they wanted this as an issue more than a bill.
Yeah, I think a couple of things are at play here. One, and I actually want to give credit, I think there were a couple of Democrats in the Senate who really are concerned about the shootings that we have and care about that more than just the issue. And I'd like to give them their due. I think that they engaged in these negotiations with the understanding that a lot of what they have proposed in the past have been non-starters, and that if they wanted to make some sort of progress, they were going to have to climb down. And so I think there was a genuineness there on that. Politically, though, I think Democrats also, they've been very desperate for the last year to show that they can get something done, right? It's been a very long time since we've seen either the House or the Senate come together and do anything since essentially the infrastructure bill that happened last summer. There's been little pieces here or there, but that's been it. So as they go into the midterm, they'd like to show that they have some ability to govern. That is certainly the case for a lot of those centrist and vulnerable House Democrats that would like to be able to take home an accomplishment as they go home over summer break.
That makes an awful lot of sense, Kim. All right. Thank you, Kyle. Thank you, Kim. Thank you all for listening. We're here every day on Potomac Watch, PW Podcast at WSJ.com for your comments and catcalls. Please join us tomorrow for another edition of Potomac Watch.